Students are responsible for their own learning. Prior to attending class, students should review this material so that there can be meaningful discussion during the training. Introduction. This manual has been designed with the building block approach. The first three modules lay a foundation for all unarmed private security professionals, regardless of the venue in which they serve: law, communications, decision making, and problem solving. Additional areas build upon this core training. Fundamentals include patrol, identity checks, scene management. These concepts open the way for specific focuses, such as fire and medical. Also, current and emerging trends, such as active threat, active shooter, bomb threats, weapons of mass destruction. Finally, when all the preceding building blocks are in place, your training culminates in report writing. This critical area will allow you to paint the picture as you document events that have arisen and how they were resolved. We have carefully ensured that all points where private security and public safety intersect, both are speaking a common language as you collaborate for successful resolution to an event. To this extent, we have ensured that, when appropriate, the curriculum taught in Oregon's public safety officers is mirrored in this training. The Board on Public Safety Standards and Training consists of 24 members appointed by the Governor. The Board, in turn, appoints 5 discipline-specific policy committees to serve as recommending bodies to the Board for the purpose of developing minimum standards for their respective industries. The Board and policy committees meet quarterly. Department of Public Safety Standards and Training, DPSST. The programs offered statewide by the Department of Public Standards and Training, DPSST, span the entire field of public safety, including police, fire, corrections, parole and probation, 911 telecommunications, private security, and polygraph examination. Mission. Our mission is to promote the excellence in public safety through the development of professional standards and delivery of quality training. Private Security Investigator Policy Committee, the PSIPC, is a 13-member committee consisting of 12 members from the private security and private investigator industries and 1 member who represents the public at large. PSIPC member contact information, the information available on the DPSST website at www.oregon.gov/DPSST. To express an interest in joining the policy committee, you may complete and submit the policy committee interest form located on the website. Private Security Listserv. Subscribe for regular updates on relevant training. Follow the link listed. IRIS, Information and Records for Investigation and Security, IRIS, allows private security professionals, the public, and employers to access information regarding the certification, licensing, employment, and training status of security professionals. Accessed via the following link. Law. Regulations applicable to private security professionals. Governmental administrative agencies, such as DPSST, are required to create specific rules defining how the statutory authority and responsibilities assigned to that agency by the legislature will be carried out. A rule is a directive or regulation that interprets law or policy, or describes the procedure or practice requirements of any agency. Definitions. Our learning outcome: understand how Oregon laws and regulations define private security professional and private security services. Private security professional defined. Oregon Administrative Rule OAR 259-060-0010 defines a private security professional as an individual who performs, as the individual's primary responsibility, private security services for consideration, regardless of whether the individual, while performing private security services, is armed or unarmed, or wears a uniform or plain clothes, and regardless of whether the individual is employed part-time or full-time to perform private security services. A private security professional is not authorized to independently contract with businesses or entities to provide services as a private security professional. Private security services defined. OAR 259-060-0010 defines private security services, means the performance of at least one of the following activities. A. Observing and reporting unlawful activity. B. Preventing or detecting theft or misappropriation of any goods, money, or other items of value. C. Protecting individuals or property, including but not limited to proprietary information from harm or misappropriation. D. Controlling access to premises being protected or, with respect to a licensee of the Oregon Liquor Control Commission, controlling access to premises at any entry to the premises or any portion of the premises where minors are prohibited. E. Securely moving prisoners. F. Taking enforcement action by detaining persons or placing persons under arrest under ORS 133.225, or providing canine services for guarding premises for the detection of unlawful devices or substances. Learning outcome of 1A2, understanding the minimum certification requirements for a private security professional. Minimum standards for unarmed private security professionals. Individuals providing unarmed private security services are required to be certified by DPSST. The minimum standards for certification are as follows: be at least 18 years of age, have earned a high school diploma, a general education diploma GED certificate, or a 2-year or 4-year post-secondary degree issued by an accredited degree-granting college or university recognized by the Oregon Office of Degree Authorization under the provision ORS 348.604. Successfully complete training, written examination, and assessment. Be of good moral fitness determined by a criminal background check and adherence to the core values of the private security industry. Page 11. Initial certification. 1. Your application package should include your PS1 application form, your PS27 Code of Ethics, PS6 Training Affidavit, PS20 Temporary Work Permit, if currently employed. This can only be used by an employing licensed manager. Fees. Acceptable payment types are cashier's check, business check, money order, credit card. No cash or personal checks are accepted. Application package should also include fingerprints. These must be submitted to DPSST. There are 3 options available: traditional ink fingerprinting, live scan fingerprinting, and electronic fingerprinting via FieldPrint ink. If using FieldPrint, you include a copy of your confirmation page. Applicants are required to enclose a processing fee for fingerprints. Fingerprinting options and information at the following link. 3. Your training, minimum of 14 hours of private security professional in-person training. PS6, training affidavit, obtained from your instructor. This must be submitted to DPSST within 180 days of the training completion date. And 4. Process this. Mail it to DPSST prior to performing private security services. Carry your PS20 temporary work permit at all times when performing the duties of an unarmed private security professional until you receive your permanent certification card. Renewal of certification. Renew your certification every 2 years. Renewal may be initiated up to 180 days prior to expiration. Renewal application packet must be received by the department prior to the expiration date to avoid a late fee. Your application packet should include your PS21 form, renewal application, PS27, Code of Ethics, PS6, training affidavit, and your PS20 temporary work permit. Submit this if employed and you are submitting renewal application materials less than 30 days prior to expiration. And your fees. 2. Your training 4-hour refresher course. PS6 training affidavit obtained from instructor. This must be submitted to DPSST within 180 days of the training completion date. Notice of deficiency. Issued because of missing or incomplete application information. You have 21 days to complete or submit incomplete or missing information. If you do not respond with the required information within 21 days, application may be administratively terminated and all paid fees forfeited. This includes discovery of a disqualifying crime or violation of temporary work permit provisions. Reporting requirements. As a private security professional, you must report your change of address, notify your employer and DPSST within 14 calendar days of change. Use the PS23 Private Security Professional Form, change of information. Report if charged with a crime. Notify your employer. If you are not employed, notify the Department of Public Safety Standards and Training no later than 48 hours after the charge is filed. If an executive manager knows that an employee has been charged with a crime, the executive manager shall notify the department no later than 48 hours after acquiring the knowledge. The department may suspend the certificate or license of a private security provider charged with a mandatory crime, pending disposition of the charge. Present your temporary work permit, certifications, or license to any DPSST staff member, law enforcement officer, or Oregon Liquor Control Commission agent upon demand, or any other person upon reasonable request. Denial, suspension, or revocation of certification or license. This rule outlines the criteria for denial, suspension, and revocation of a certification or license. Mandatory grounds. DPSST must deny or revoke the certification or license of any applicant or private security provider who is required to register as a sex offender or has been convicted of certain crimes listed in OAR 259-060-0300. Discretionary grounds. DPSST may deny or revoke the certification or license of any applicant or private security provider if the individual A. fails to meet the minimum standards for certification or licensure as a private security provider as defined in OAR 259-060-0020. B. Has falsified any information submitted on the application for certification or licensure, or any documents submitted to the department pertaining to private security certification or licensure. C. Has violated any of the temporary assignment provisions of OAR 259-060-0120. 1. D. Has failed to submit properly completed forms or documentation in a time frame as designated by the department. E. Has failed to pay a civil penalty or fee imposed by the department when due. F. Has failed to comply with any provision found in the Act or these rules. Or G. Lacks moral fitness. See Moral Fitness and Code of Ethics, page 15. Moral fitness and the Code of Ethics. This rule provides all private security providers must be of good moral fitness as determined by a criminal background check, department investigation, or other reliable sources. Good moral fitness requires compliance with the following core values. Honesty includes integrity, credibility, acting honorably, and maintaining confidences. Character, good character includes being respectful and courteous, being faithful, diligent, and loyal to the employer's charge, using discretion, demonstrating compassion, and exhibiting courage. Fair treatment of others includes treating others equitably, demonstrating good judgment, and not being discriminatory. Public trust includes maintaining public confidences, being law-abiding, and adhering to the recognized industry standards, and respect for the laws of this state and nation. Lack of good moral fitness includes, but is not limited to, mandatory and discretionary disqualifying misconduct. Code of Ethics. Private security professionals are required to sign a private security code of ethics affirming moral fitness and professional standards. Within this code of ethics, the core values are cited. Code of Ethics. I swear or affirm that as a private security provider, my fundamental duty is to protect the interest of my employer, client, and or the industry. As a private security provider, I recognize that I am bound to the core values specific to my discipline. I acknowledge that honesty is a core value that includes integrity, credibility, acting honorably, and maintaining confidences. I acknowledge that a lack of honesty includes untruthfulness, dishonesty by admission or omission, deception, misrepresentation, or falsification, and from these I will abstain. I acknowledge that good character is a core value that includes being respectful and courteous, being faithful, diligent, and loyal to the employer's charge, and using discretion, demonstrating compassion, and exhibiting courage. I acknowledge that fair treatment of others is a core value that includes treating others equitably, exercising good judgment, and not being discriminatory against others. I acknowledge that public trust is a core value which includes maintaining the public confidence by being law-abiding and adhering to recognized private security industry standards. I acknowledge that respect for the laws of the state and nation is a core value. I will constantly strive to maintain these core values, dedicating myself to my chosen profession. Page 17. Types of violations that may result in a civil penalty. DPSST may recommend civil penalties upon finding a private security provider has engaged in any of the following. A. Providing private security services without valid certification or licensure or temporary work permit. B. Failure to submit properly completed forms or documentation in a time frame as designated by the department. C. The falsification of any documents submitted to the department. D. Failure to cease providing private security services upon issuance of a cease and desist order, expiration of certification or licensure, notice of termination, suspension, denial, or revocation. E. Failure to complete required training as prescribed in OAR 259-060-0060. F. Failure to report criminal charges as required in ORS 181A 885. G. Providing training without a valid certification. H. Failure of a private security instructor to instruct the full department-approved curriculum. I. Failure to terminate employment as a private security provider of an individual whose application has been terminated or whose certification or licensure has been suspended, denied, or revoked upon notice from the department to do so. J. Employing private security providers who have not completed the training and application process required under the Act and these rules. K. Failure to employ a licensed executive manager. L. Failure to provide technological communication or visibility of a certified security professional to crowd management staff. M. Failure to provide documentation of one certified security professional to 10 crowd management staff. N. Expecting crowd management staff to perform security services duties other than the duties incidental to crowd management, or O. Any other violation of requirements of the Act or these rules. Page 18. Civil Law. The learning outcome of this is to understand the difference between civil law and criminal law and the elements of a tort. The difference between civil law and criminal law is that civil law deals with legal matters between private parties, such as requiring party A to pay party B if A injures B. This is a tort. Or if A fails to abide by a legal agreement, contract, with B, dispute between individuals. Criminal law deals with conduct considered by society as a whole that is prohibited by statute and punishable by the government. Wrongs for which the government prescribes a legal punishment. Learning outcome of 2A2. Understand the concepts of torts that private security professionals may encounter. Specific torts. A tort is a private wrong or injury other than breach of contract, for which the court will provide a remedy in the form of a legal action to recover damages, compensation for the loss, as discussed below. Every tort has three essential elements. One party has a legal duty to another, often the duty to exercise due care. 2. The party breaches that legal duty. And 3. The other party or their property is injured or damaged as a direct result. Simply stated, if you commit a tort or torturous act, you can be sued for damages by the injured party. If you commit a crime, you can be charged and prosecuted by the government body and penalized. Some acts, such as trespass and assault, may be both torts and crimes. In this discussion of torts, the term plaintiff means the person claiming to have been injured or damaged and seeking to hold the defendant responsible to pay for the injury or damage. Defendant means the person causing the injury or damage. Page 19. Negligence. Probably the most common tort is negligence, which can be defined as the failure to exercise the care towards others which is a reasonable and prudent person would exercise in the circumstances, resulting in an injury to another party. Example, a driver fails to be attentive while driving and crashes into another vehicle, injuring the occupants. Intentional torts include the following: assault and battery, The tort of assault occurs when defendant acts intentionally in a way that causes plaintiff to reasonably fear an immediate harmful contact. Assault involves a threat. The tort of battery is when the intentional act actually causes offensive or harmful contact with the other party. Battery involves actual harmful physical contact. False imprisonment and false arrest. False imprisonment is when defendant forcibly and without legal justification detains plaintiff or confines his or her freedom of movement. The force involved can be either actual physical force or a threat of force. False arrest is when defendant unlawfully detains plaintiff at the time of arrest. The distinction between the two is that false imprisonment can occur with or without an arrest. If a private security professional or store owner unlawfully detains someone, they may be liable for false arrest or false imprisonment. Reference Citizen's Arrest, page 22. Page 20. Conversion. Theft. This is the tort equivalent of theft. The tort of conversion occurs when defendant takes possession and control over plaintiff's property without plaintiff's permission. Example, taking a person's fake ID and refusing to return it for a period longer than reasonably necessary to examine it. Intentional infliction of emotional distress. This tort occurs when defendant intentionally or recklessly causes severe emotional distress to plaintiff by means of extreme or outrageous conduct. Whether the conduct is extreme or outrageous in a particular case is not clearly defined and would be a question for the jury or judge to decide. Fraud. The tort of fraud, sometimes referred to as deceit, occurs when defendant falsely represents a present or past fact to plaintiff, who then acts in reliance on that misrepresentation and incurs a loss, damages as a result of that reliance. Example, with no legitimate basis for doing so, you tell a citizen they must leave a movie theater after they have paid for their ticket, and they do so, missing out on the services that they paid for. Trespass. The tort of trespass occurs when defendant intentionally enters plaintiff's land or interferes with plaintiff's ownership of the property, if plaintiff incurred injury or damage as a result. Defamation. Defamation occurs when defendant makes a false statement of fact, as opposed to an opinion, about plaintiff. This false statement must be published, that is, communicated to one or more people other than the plaintiff. Further, plaintiff must prove defendant knew or should have known the statement was false. Finally, plaintiff must prove he or she suffered some harm as a result. Written defamation is called libel, and spoken defamation is called slander. Damages. In the context of tort law, this term refers to the amount of money awarded by a court to a plaintiff who has been injured or incurred property damage because of the wrongful conduct of defendant. Page 21. Limited authority of a private security professional. In general, a private security professional has no more authority than any other citizen. If the private security professional is working for a property owner, the property owner's authority can be granted to the private security professional. This granted authority must be detailed in the private security contract, agreement, or through post orders. Further limitations. The private security professional may not engage in conduct that is restricted by law. A private security company may further restrict the authority of the private security professional beyond what is granted by the property owner. Laws pertaining to citizen's arrest. Citizen's arrests could result in civil torts such as assault, battery, false imprisonment, and false arrest. There are statutes in Oregon that provide some clarity on when a private citizen may effect a citizen's arrest. and when physical force may be used in the course of such an arrest. Arrest by a private person, ORS 133.225. 1. A private person may arrest another person for any crime committed in the presence of the private person, if the private person has probable cause to believe the arrested person committed the crime. A private person making such an arrest shall, without unnecessary delay, take the arrested person before a magistrate, or deliver the arrested person to a peace officer. See clarifying explanation. 1. In order to make the arrest, a private person may use physical force as is justifiable under ORS 161.255, use of physical force by private person making citizen's arrest. Clarifying explanation of take the arrested person before a magistrate or deliver. Transporting the arrested individual to a magistrate is neither practical nor legally prudent. While the statute says you may deliver the arrested individual to a peace officer, this should not be interpreted to mean transport of the individual. Rather, you should seek first to gain the arrested individual's consent to wait for responding police. If the individual tries to escape from your citizen's arrest, you must determine if you reasonably believe it is necessary before you use physical force to prevent the escape, in reliance upon the use of force statute pertinent to citizens' arrests. Page 23. Probable cause for citizens' arrest. ORS 133.225 authorizes citizens' arrest when you have probable cause to believe the person has committed a crime in your presence. This requires you to understand A. The elements of the crime. Reference Criminal Law, page 39. B. The term probable cause, and C. The meaning of in the presence. Probable cause definition. Defined at ORS 131.005.11 to mean there is substantial objective basis to believe that more likely than not an offense has been committed and a person to be arrested has committed it. Private security professionals, like other private persons, are only authorized to make the arrest if the crime was committed in their presence, and they have probable cause to believe the person they are arresting committed the crime. Only police officers can arrest based on probable cause alone, even if the crime was not committed in their presence, such as through witness statements and other evidence. Agent of law enforcement. On occasion, a police officer may request a private security professional to assist the officer with an investigative task, inquiry, etc. This often generates a belief or a concern on the part of the private security professional that if they comply, they are acting as an agent of law enforcement. Whether or not a person in any given instance is acting as an agent of a police officer is a complex legal issue, the resolution of which is dependent on the particular facts and circumstances. Potential negative outcomes, such as an officer losing seized evidence in a motion to suppress, are appropriately considered by the police officer, perhaps in consultation with the district attorney's office or the court. If you have questions about whether or not you should or must comply with such a request, ask the officer. If you have concerns about your authority to comply, consult with your employer. Interacting with juveniles. Taking a juvenile into custody is the equivalent of an arrest, but technically is not officially considered an arrest. Nevertheless, a juvenile is taken into custody. Similar rules apply to turning them over to law enforcement without unnecessary or undue delay. One notable difference is, if the parents or legal guardians of the juvenile arrive prior to law enforcement, the private security professional must release the juvenile to them. Use of force. A private security professional may use the force reasonably believed to be necessary to defend themselves or another person, prevent or terminate a criminal trespass, protect property, or make a citizen's arrest or prevent an escape after making a citizen's arrest. Critical reminder: a private security professional has no legal duty to take action and may retreat if safe and practical to do so. Reasonable and necessary. Any use of force must be reasonably believed to be necessary. Even if force is intended for a statutorily recognized purpose, such as self-defense, if the user does not reasonably believe the force is necessary to achieve the lawful purpose, then the force is unlawful. Use of physical force by a private person making citizen's arrest. ORS 151.255. Except as provided in subsection 2 of this section, a private person acting on the person's own account is justified in using physical force upon another person when and to the extent that the person reasonably believes it necessary to make an arrest or to prevent the escape from custody of an arrested person whom the person has arrested under ORS 133.225, arrest by a private person. 2. A private person acting under the circumstances prescribed in subsection 1 of this section is justified in using deadly physical force only when the person reasonably believes it necessary for self-defense or to defend a third person from what the person reasonably believes to be the use or imminent use of deadly physical force. Directed or voluntary use of force by a private citizen on behalf of law enforcement. The ORS provision which is relevant to this discussion is ORS 161.249, use of physical force by private person assisting an arrest. It provides 1. Except as provided in subsection 2 of this section concerning the potential use of deadly force, a person who has been directed by a peace officer to assist the peace officer to make an arrest or to prevent an escape from custody is justified in using physical force when and to the extent that the person reasonably believes that force to be necessary to carry out the peace officer's direction. Emphasis added. The above statute is not a statute which defines the elements of a crime. Rather, it is a force justification statute. A private person who complies with the officer's direction and who reasonably believes he or she needs to use physical force to do so would be justified in using this physical force. Therefore, if their use of force resulted in injury or death of a person, the defense of justification should insulate the person from potential criminal liability. Notice, though we say if the private person complies with the officer's direction. This is related to the next conversation, wherein we see the legislature has declined to make failing to assist a crime. While the legislature declined to create criminal consequences for a private citizen who unreasonably refuses or fails to assist, they did provide a defense to criminal liability for the person who does comply and reasonably believes they need to use force to do so. Lastly, it is important to distinguish a private citizen who is directed by a peace officer to assist from one who is a volunteer. The use of force statute above would not apply to create a defense to criminal liability for a volunteer. If such a person, for example, came to the aid of a police officer because they were concerned the officer was being harmed by someone who the officer was trying to arrest, then the private citizen would presumably be protected by the defense of self or defense of a third person use of force statute. Refusal to assist law enforcement. The ORS provision which is relevant to this discussion is ORS 162.245, refusing to assist a peace officer. It provides, a person commits the offense of refusing to assist a peace officer If upon command by a person known by the person to be a peace officer, the person unreasonably refuses or fails to assist in effecting an unauthorized arrest or preventing another from committing a crime. Equally important as the language of the offense is its potential penalty. The Oregon legislature has chosen to designate the offense as a B violation, punishable only by a maximum fine of $1,000, with a presumptive fine of only $260. We use the word only to stress the legislature's decision to ascribe low severity to this offense. Furthermore, successful proof of the offense requires the government to prove, by a preponderance of the evidence, that the person unreasonably refused or failed to assist. It would be difficult to argue that a private citizen is being unreasonable if he or she were to hesitate when being commanded to assist in effecting the arrest of another person, or to prevent another person from committing a crime. A civilian would be understandably hesitant due to the risks present when coming into close contact with an unknown person who has drawn the attention of the police. It would appear that if the legislature were more concerned about making sure all civilians complied when so commanded, they would have made it a crime to refuse. They did not. Detaining, holding, transporting. A private security professional may not detain another citizen unless a citizen's arrest has been made. A private security professional who has made a citizen's arrest must turn the arrestee over to law enforcement without undue delay. If law enforcement does not arrive within a reasonable time, the arrestee should be released. It is then the role of law enforcement to find and arrest the suspect. See explanation of take or deliver arrested person, page 22. A private security professional should keep the person they have placed under citizen's arrest on the same property where the crime was committed. Definition of detain: to officially prevent someone from leaving a place, or to hold or keep someone in a prison or some other place. To keep or prevent someone from leaving or arriving at the expected time. Detention and interrogation of persons suspected of theft committed in a store or unlawful operation of audio-visual device in a motion picture theater. ORS 131.655. Probable cause. Notwithstanding any other provision of law, a person may be detained in a reasonable manner and for a reasonable time by a merchant or merchant's employee who has probable cause for believing that the person has committed theft of property of a store or other mercantile establishment, or B, the owner or lessee of a motion picture theater or authorized agent or employee of the owner or lessee who has probable cause to believe that the person has violated ORS 164.882, unlawful operation of an audiovisual device. 2. Probable cause is a defense to any civil or criminal action based on detention and interrogation that a person brings against a merchant or merchant's employee who has detained the person in a reasonable manner and for a reasonable time based on probable cause for believing that the person has committed theft of property of a store or other mercantile establishment, or a the owner of or lessee of a motion picture theater or authorized agent or employee of the owner or lessee who has detained the person based on probable cause for believing that the person has violated ORS 164.882, unlawful operation of an audiovisual device, formerly 133.037. Page 30. Searching the person or property of another. Consent to search. Private security professionals may need to search people in order to recover property or for their own safety. but there are legal restrictions on searching people or their property. Legally, the safest way to conduct a search is to obtain the person's consent. Example: you ask a person entering a nightclub if you may search their backpack, and the person says, "Sure, go ahead." That should be considered valid consent. Searching citizens upon entering a facility. Persons entering a facility for business or personal reasons are often required to submit to a search in order to gain access to the facility. Private security professionals may operate metal detector stations and perform physical pat-downs, as well as baggage checks for those entering or leaving the facility. Although searches and pat-downs may be required for a person wishing to enter the facility, no private security professional has a right to force these searches to occur. If the person has consented in writing to the search, they may withdraw that consent at any time. While a person may be denied entry to a facility for refusing to submit to such policies, the private security professional may not force a search of someone even if they have already gained access. To compel someone to submit to any search or pat-downs may be grounds for a civil tort lawsuit, as well as a potential criminal charge against the private security professional. Page 31. Searching citizens upon leaving a facility. Even if the client's policy is to allow inspection of the baggage of persons leaving the property, a private security professional may not lawfully detain someone who refuses to submit to a search, and may not detain their baggage unless the elements necessary for a citizen's arrest are present. Merely suspecting a person of stealing because they refuse to allow a search of their baggage is not sufficient grounds to lawfully detain or place a person under citizen's arrest. Unless the private security professional has personally witnessed a crime occur in their presence, the most advisable action is to report such a person's refusal to allow the search and allow that company to investigate, rather than act without the full facts and potentially incur a lawsuit. Lawful owner of property to be searched. In conducting searches of property such as vehicle or a purse, the consent to search must be from the lawful owner or person in charge of that property. When in doubt, it is advisable not to conduct the search until proper authorization has been obtained. If police involvement is expected and there is a question as to the legal right to search, wait for the police to conduct searches in a manner that reduces the risk of liability. Page 32. Surveillance. Privacy law and surveillance. Private security services often involve observing and reporting on the activity of others. These observations are accomplished by conducting surveillance, which is the purposeful act of scrutinizing the activity of another. Sometimes this is accomplished by the unaided eye, sometimes with the help of special tools. Guidelines. As a general rule, each person has the right to privacy in areas where there is a reasonable expectation of privacy. Whether or not privacy laws are violated depends on the reasonableness of the expectation of privacy. Example: if you inadvertently, unintentionally see someone undressing through their open window as you drive on a public street, that person does not have a reasonable expectation of privacy. If you approach the person and peek through a crack in closed blinds, you have violated their expectation of privacy. Electronic surveillance. The laws regarding the use of electronic equipment used to conduct surveillance, cell phone, cameras, video, listening devices, etc., are complicated and change frequently. Consult your client's or employer's policies relating to electronic surveillance. Use these guidelines when video recording others. In a private place such as a bathroom, there is an expectation of privacy. In a public place, there is diminished expectation of privacy. Depending on the authority granted to you or your company by a property owner, you may have the authority to restrict or prohibit all types of activity, including video recording, on a property being protected. Recording conversations. It is illegal in Oregon to record a phone conversation unless consent is given by at least one participant in the conversation. It is illegal in Oregon to record other conversations unless all parties to the conversations are informed it is being recorded. A qualifier on this statute is found in subsection 6C, which reads, "Prohibitions do not apply to persons with an unconcealed recording device that are part of a private meetings or conferences if all others involved knew or reasonably should have known that the recording was being made." Page 34. Civil Rights and Discrimination Laws. State Law. ORS 659A 403 provides as follows: except as provided in subsection 2 of this section, all persons within the jurisdiction of this state are entitled to the full and equal accommodations, advantages, facilities, and privileges of any place of public accommodation, without any distinction, discrimination, or restriction on account of race, color, religion, sex, sexual orientation, national origin, marital status, or age, if the individual is 18 years of age or older. 1. Subsection 1 of this section does not prohibit a. the enforcement of laws governing the consumption of alcoholic beverages by minors, and the frequenting by minors of places of public accommodation where alcoholic beverages are served, or b. the offering of special rates or services to persons 50 years of age or older. 2. It is an unlawful practice for any person to deny full and equal accommodations, advantages, facilities, and privileges of any place of public accommodation in violation of this section. Place of public accommodation. A. Any place or service offering to the public accommodations, advantages, facilities, or privileges, whether in the nature of goods, services, lodgings, amusements, transportation, or otherwise. B. Any place that is open to the public and owned or maintained by a public body as defined in ORS 174.109, public body defined, regardless of whether the place is commercial in nature. C. Any service to the public that is provided by a public body as defined in ORS 174.109, public body defined, regardless of whether the service is commercial in nature. It is also unlawful to aid or abet in prohibited acts of discrimination in any place of public accommodation. Civil recourse. Any person who has been discriminated against by any employee or person acting on behalf of a place of public accommodation in violation of these statutes can bring a legal claim against the operator or manager, against the discriminating employee or person acting on behalf of the place of public accommodation, and or any abettor in the discrimination. Federal law. There is no common law claim such as claim in tort for recovering damages from a person or entity that has violated one's rights protected by the U.S. Constitution. However, federal legislation provides such a remedy by statute. Specifically, the law provides every person who, under the color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws, shall be liable to the party injured in any action at law, suit in equity, or other proper proceeding for redress. Generally, under the color of any statute, applies only to government action, public bodies. Therefore, unless you are working for a public entity, this would not be applicable. Claims against public bodies and public employees under this statute are common in cases alleging false arrest or imprisonment, excessive force, impingement of First Amendment rights, speech, assembly, religion, and violations of due process rights. See Agent of Law Enforcement. Page 24. Page 36. Disability discrimination. ADA Title III, Places of Public Accommodation. The ADA is a wide-ranging civil rights law prohibiting discrimination based on disability. Much of the ADA deals with employment. Title I, Public Entities and the Public Transportation. Title II, and is not very likely to impact your work in a private security. Title III, however, prohibits discrimination on the basis of disability in the activities of places of public accommodation. Businesses that are generally open to the public and that fall into one of the 12 categories listed in the ADA, such as restaurants, movie theaters, schools, daycare facilities, and recreation facilities. Definition. Under the ADA, an individual with a disability is defined as a person who has physical or mental impairment that substantially limits one or more major life activities, a person who has a history or record of such an impairment, or a person who is perceived by others as having such an impairment. The area where private security professionals are most likely to come in contact with disability discrimination law is in the context of laws regarding service animals. Page 37. Service animals. Definition. OAR 736-010-0015 defines a service animal as any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. The work or tasks performed by a service animal must be directly related to the handler's disability. The crime deterrent effects of an animal's presence and the provision of emotional support, well-being, comfort, or companionship do not constitute work or tasks for the purposes of this definition. The crime deterrent effects of an animal's presence and the provision of emotional support, well-being, comfort, or companionship do not constitute work or tasks for the purposes of this definition. The Department of Justice revised ADA regulations include a new provision for miniature horses that have been trained to do work or perform tasks for people with disabilities. Where service animals are allowed: state and local governments, businesses, and nonprofit organizations that serve the public generally must allow service animals to accompany people with disabilities in all areas of the facility where the public is normally allowed to go. Service animals must be under control. Service animals must be harnessed, leashed, or tethered unless these devices interfere with the service animal's work or the individual's disability prevents using these devices. In that case, the individual must maintain control of the animal through voice, signal, or other effective controls. Page 38. Applicability. Comfort, therapy, or emotional support animals do not meet the definition of an assistance animal. A guide dog puppy that is being raised and trained to be a guide dog should be afforded the same privileges as a certified guide dog. Limited inquiries about service animals. In situations where it is not apparent that the animal is a service animal, a business may ask two questions to help determine whether the animal may be properly permitted into the business. Is the animal required because of disability? And what work or task has the animal been trained to perform? Two questions. Is the animal required because of a disability? What work or task has the animal been trained to perform? No other inquiries about an individual's disability or the service animal are permitted. Businesses cannot require proof of certification or medical documentation as a condition for entry. Page 39. Criminal Law. Overview. As we have just seen, civil law, including tort law, deals with the legal relationships and legal disputes between private parties. Criminal law, on the other hand, deals with the rules and statutes that define conduct prohibited by the government because it threatens and harms public safety and welfare, and that establishes punishment to be imposed for the commission of such acts. Classes of offenses. An offense is conduct for which a sentence to a term of imprisonment or to a fine is provided by any law of this state or by any law or ordinance of a political subdivision of this state. An offense is either a crime or a violation. Violations are a type of offense punishable only by a fine, forfeiture, suspension, or revocation of a license or other privilege, or other civil penalty. Crimes are either felonies punishable by prison terms of more than 1 year to life, or misdemeanors punishable by local jail terms of 1 year or less. Note that all crimes may also result in the imposition of fines. Felonies and misdemeanors are further classified by statute in order of severity, Class A, B, C, or unclassified, with C being the least and A being the most severe. Page 40. Requirements for criminal liability. Every crime has elements that must be proven by the prosecutor in order to convict the person charged. These elements can be broken into two categories: the conduct or act and the mental intention known as culpable mental state. What is important for you to understand is that individuals are not criminally punished for involuntary or accidental conduct. Example 1. A woman shows a man a crystal vase she has just purchased. The man drops it and the vase shatters. Because this was involuntary and accidental, no criminal charge would result. On the other hand, if he intentionally damaged it, there could be a criminal charge. Example 2. A man loses his balance and accidentally bumps into another person, resulting in that person falling down the stairs and injuring himself. This was involuntary and accidental. No criminal charge would result. On the other hand, if he intentionally shoved the person down the stairs, causing injury, there would be a criminal charge. Page 41. Property crimes generally deal with acts that affect property or one's interest in property. Criminal trespass means one enters the premises of another unlawfully or unlawfully remains. Open to the public means premises by which the physical nature, function, custom, usage, notice, or lack thereof, or other circumstances at the time would cause a reasonable person to believe that no permission to enter or remain is required. Person in charge means a person, representative, or employee of the person who has lawful control of the premises by ownership, tenancy, official position, or other legal relationship. It includes, but not limited to, the person or holder of a position, designated as the person or position holder in charge by the governor, board, commissioner, governing body of any political subdivision of this state. Enter or remain unlawfully means to enter or remain in or upon premises when premises at time of entry or remaining are not open to the public, and when the entrance not otherwise licensed or privileged to do so. To fail to leave premises that are open to the public after being lawfully directed to do so by person in charge. To enter premises that are open to the public after being lawfully directed not to enter the premise, or to enter or remain in a motor vehicle when the entrant is not authorized to do so. Page 42. Criminal trespass can be established when the owner, tenant, or person in charge or security company, if authority has been delegated, publishes notice to the trespasser either verbally or in writing. Verbal notice such as, "You are on private property, leave now." Written notice, such as an ejection or trespass notice. If the trespasser then refuses to leave or leaves the property and returns without permission. If the trespasser enters the property not open to the public unlawfully, such as a house or a fenced area with posted no trespassing signs, no prior notice of ejection is necessary. Burglary in the second degree. Burglary in the second degree occurs when a person enters or remains unlawfully in a building with intent to commit a crime therein. Theft. Theft means with intent to deprive another of property. The person takes appropriates, obtains, or withholds such property from an owner. Examples: takes, obtains, or withholds such property from an owner, commits theft of property lost, mislaid, or delivered by mistake, commits theft by extortion, or commits theft by deception or by receiving property. Robbery in the third degree. Robbery in the third degree occurs when a person in the course of committing or attempting to commit theft uses or threatens the immediate use of physical force upon another with the intent of preventing or overcoming resistance to the taking of property. Page 43. Criminal mischief. Criminal mischief offenses usually involve damage to property. Criminal mischief 3 does not require an intent to damage property. It includes tampering or interfering that is intended to cause inconvenience. Criminal mischief 2 includes any criminal mischief 3, no intent, that results in more than $500 in damages, or any intentional property damage regardless of dollar value of damage, or any reckless damage more than $500. Talking point: the differences between robbery and burglary are that robbery requires the crime of theft or UUV, unauthorized use of a vehicle, to be underlying crime. Burglary includes the intent to commit any crime. Robbery requires the use or threatened use of force against the victim. Burglary does not require the presence of a victim. Burglary requires entering or remaining unlawfully in a building. Robbery can be committed anywhere. Page 44. Person crimes. Harassment includes, but is not limited to, when a person intentionally harasses or annoys another by subjecting them to offensive physical contact, or distributing a visual recording, sexting, as defined in ORS 163.665, of the other person engaged in sexually explicit conduct, as defined in ORS 163.665, or in a state of nudity, as defined in ORS 163.700, when the other person is under 18 years of age at the time of the recording. Assault. Assault 4 is the intentional, knowing, or reckless causing of physical injury. It can be criminally negligent if committed with a deadly weapon. Assault 3 is usually either an assault 4 committed intentionally, knowingly by more than one perpetrator, or the reckless causing of serious physical injury with a dangerous or deadly weapon. Assault 2 is usually intentionally or knowingly causing serious physical injury. Assault 1 is intentionally causing serious physical injury with a dangerous, deadly weapon. Definitions: a dangerous weapon is any instrument, article, or substance that under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing death or serious physical injury. Deadly weapon is any instrument, article, or substance designed for and presently capable of causing death or serious physical injury. Deadly physical force is physical force that, under the circumstances in which it is used, is readily capable of causing death or serious physical injury. Intimidation occurs if, because of a person's perception of another's race, color, religion, sexual orientation, disability, or national origin, the person tampers or interferes with the property of another with the intent to cause substantial inconvenience, subjects another to offensive physical contact, or subjects another to alarm by threats to inflict serious physical injury to that person or a member of their family, or to cause substantial damage to the property of another member of their family. Disorderly conduct 2 occurs when, with intent to cause public inconvenience, annoyance, or alarm, or recklessly creating a risk thereof, the person engages in fighting or violent, tumultuous, or threatening behavior. Makes unreasonable noise. Note, this will not hold up if the person is engaged in constitutionally protected speech. Disturbs any lawful assembly of persons without lawful authority. Obstructs vehicular or pedestrian traffic on a public way. Initiates or circulates a report, knowing it to be false, concerning an alleged or impending fire, explosion, crime, catastrophe, or other emergency, or creates a hazardous or physically offensive condition by any act which the person is not licensed or privileged to do. Page 46. Evidence. Protecting evidence. The rules of evidence allow a court trial to proceed fairly and quickly, using only evidence that is relevant, reliable, and accurate. Notes and reports. The private security professional's notes and reports are admissible in evidence to refresh the memory of the security professional who wrote them. Example: if asked what color eyes that person had, the security professional may ask to refresh their memory by referring to their report or notes. Photographs. Photographs are admissible if the photographer can testify that the photograph is an accurate representation of the scene at the time the photograph was taken. Physical evidence. To be admitted in a trial, physical evidence must be demonstrated to be what it purports to be. To be acceptable to the court, a chain of custody must be established. This is a process that involves these main elements. The evidence collector properly identifies the evidence. The evidence collector tamper-proofs and secures evidence at the collection site. Example: you locate a knife believed to be used in a crime. You remain with the knife, ensure it is undisturbed until the police arrive and take custody of it. You then document in your report where you found the knife and who it was turned over to. As best practice, allow police to process all physical evidence. Page 47. Testimony. In the course of your work as a private security professional, you may be called to testify in court in either a civil case or a criminal case, or to give your deposition. This could be either by informal request or by means of a court-issued subpoena. A deposition is a proceeding often in an attorney's office, where you are sworn in and questioned by the attorneys in the presence of a court reporter. The allowable range of questioning in a deposition is much broader than in a trial. When preparing to testify as a witness, whether in trial or deposition, the private security professional should note the following. Dress properly. In a courtroom, the proper attire is a uniform or business attire. If in doubt, check with the employer or the attorney seeking your testimony. Typically, it would be the prosecutor in a criminal case requesting your appearance as a witness, or the attorney representing the party seeking your testimony in a civil case. Either way, you would most likely meet with the attorney to prepare you for the court appearance or deposition. Refresh your memory of the incident by reviewing all reports, statements, and related records. It is vital to be completely honest, even if parts of the event are embarrassing. When testifying as a witness, private security professionals should first look at the person asking the questions, counsel the prosecutor or judge, and when answering the questions, look at the jury or judge. Truthfulness is the most important requirement of a witness. If even a small part of your testimony is shown to be untruthful or exaggerated, the jury might very well be skeptical of your overall credibility. Communication. Communicating with emotional or angry citizens. Tactical communication defined: the strategic use of verbal and nonverbal messages to accomplish a specific goal of voluntary compliance. 6 principles of effective communication. 1. Professionalism, public perception. Professional mindset. You represent more than yourself. You represent your organization and profession. Your intentions are inconsequential in relation to how you are viewed as a private security professional. Everyone deserves dignity and respect. The way you treat people dictates your success. Tactics for communicating professionalism. Present a conscientious demeanor. Maintain your uniform. Make eye contact. Assume an active listening posture. Control your expressions. Remain calm and collected. Utilize common courtesy. Greet people. Smile when appropriate. Refer to people as Mr., Miss, Sir, Ma'am. Identify yourself. Explain your purpose and actions. 2. Assessment. Evaluate quality of response, or their readiness, willingness, or ability to cooperate. Assessment requires observation and listening. 3. Observation. Identify problematic behavior cues. Self-affecting behavior includes red face, gritting teeth, facial tics, rapid breathing, clenched fists, closed posture, crying and stuttering or broken speech. Attention-seeking behaviors include fixed stares, inappropriate remarks, yelling, arguing, disobeying direction, making threats, invading personal space. Pre-assaultive behavior, imminent attack, includes pacing, rocking, shifting weight, target glancing, preparatory posturing, personal grooming, article moving, striking self or structures. 4. Listening. The key to listening is remaining silent in order to receive messages. Suspend personal judgment. Take an interest in the situation. Demonstrate your attentiveness. Empathize. Prompt additional information. 5. Assessment conclusion. Assess immediately, then continuously. Develop plans accordingly. Pay attention to the effects of your actions. Do not rush to discuss or problem solve unless necessary. Take the time to recognize the circumstances that surround you so that you can effectively interact and gain control of the situation. 6. Interact positively. Giving direction. Use clear directions. Focus on who you are speaking to. Provide opportunities to comply. Ensure direction is realistic in the present circumstance. Explain when necessary. Gain cooperation. Maintain your professionalism. Set the context for the situation. Provide an opportunity for justification. Explain processes, their purposes, and consequences. Provide a reason for your response to requests. Persuade toward a common goal. Provide options when applicable. Transfer accountability. Do you understand your decision may have consequences? Ask guideline questions. How can we resolve this? Diffuse emotional, difficult, or hostile situations. Relieve anxiety and avoid escalation. Maintain a calm demeanor. Allow venting. Develop rapport. Empathize. Ask questions. Distract. Actions that escalate. Inappropriate facial expressions. Aggressive posturing. Sarcasm. Profanity. Apathy. Degrading comments. Unenforceable threats. Entering an ego contest. Control the situation. Project authority, but do not rely on it. Set and maintain boundaries. Avoid direct order syndrome. Do it now. Be flexible and adapt to assessed circumstances. Avoid excessive repetition. Adjust. Utilize verbal skills to alleviate potential problems. Recognize when words fail. Know your laws, your audience, and yourself. Consider the best option for the situation. Choose the best option for you to be successful. Page 51. Communicating with the mentally ill. Because you interact with the public, you will likely encounter individuals who may have mental health issues. The overview of the types of mental illness is for information at an awareness level. It is more important for you to recognize common characteristics so that you can use the subsequent tools, verbal and nonverbal skills, to communicate and de-escalate situations while awaiting the response of trained personnel. The major types of mental illness. Schizophrenia, a mental disorder characterized by persistent defects in the perception of reality. They will often experience delusions or hallucinations. Bipolar, manic depression. Mood swings from depression to manic highs, mental or physical hyperactivity. Major depression, a persistent state of depression that significantly affects one's mood and daily activities. It has a direct link to suicide. Anxiety disorders may be uncontrolled worry, uncontrolled obsessions, obsessive-compulsive disorder, or panic, which is the abrupt onset of intense fear or discomfort. Post-traumatic stress disorder, PTSD, from prior traumas is also in this category. Personality disorders include paranoid, distrust of others, schizoid, limited range of emotion, schizotypal, odd, eccentricities, antisocial, lack of regard for moral or legal standards. Common characteristics of mental health disorders: perception, hallucinations, orientation, person, place, time awareness. Thinking, delusions, paranoia. Judgment, insight, poor decision making. Behaviors, actions, movements. Environment, unusual items or unusual use of items. Page 52. Verbal skills. 1. Tell citizen you are there to help. A. Introduce self by first name. B. Ask and use their name. C. Do not involve yourself in their delusions. Show you understand that they believe it is really happening. 2. Ask clarifying questions in terms of I statements. A. I don't understand this. B. I'm afraid that you'll hurt yourself. C. I can't figure out why. 3. Use personalized statements. You holding that rock makes me nervous. 4. Do not argue. 5. Actively listen. A. Do not be afraid of silence. B. Wait for responses. C. Echo their feelings. You seem to be angry. 2. Show concern and understanding. A. Nod head while they are talking. B. Indicate listening with I see or aha, etc. 7. Treat citizen with respect. 8. Do not use offensive terms or sarcastic remarks. 9. Tell citizens what you are going to do and do not make promises you cannot keep. 10. If citizen becomes agitated, change the subject. Page 53. Nonverbal skills. 1. Feedback loop. A. Watch reactions of the citizen to you. B. Stop action if it escalates the citizen. 2. Open body language. Rule of palm. Talk with your palms open. Stand slightly to the side, balanced. Take safe but not defensive stance. More relaxed posture. Head tilted. Be ready. Appear relaxed. 3. Eye contact. Try to make eye contact. Some citizens like it as a sign of personal contact and rapport. May make some people nervous. B. Try to remain at eye level. 4. Body space. A. Rule of 3. Remain at least 3 arms lengths away at first contact. May need to move in to establish personal rapport. C. Move slowly and announce action to the citizen. 5. Officer safety. A. Never deny the possibility of violence. Persons with mental illness are not more violent than normal population, but may be more unpredictable. B. If hearing voices, ask what the voices are saying. If their voices are telling them to hurt, kill someone, self or others, take that very seriously and disengage if need be. Keep relaxed approach, but not complacent. D. Watch their hands. Interacting with public safety. When interacting with public safety, articulate your observations of the citizen, such as their behaviors, responses, and what the issues are relating to your role and your scope of authority over the property on behalf of the property owner. This will allow public safety to more fully understand the situation and respond appropriately. Page 54. Communicating with 911. Emergency versus non-emergency. When prioritizing an emergency versus non-emergency situation, individuals should consider the immediate need for attention, such as threat to life, threat to property, or an active crime or incident. A non-emergency is a situation that poses no immediate risk to health, life, property, or environment. Non-emergency situations may still require assistance from emergency services. Call the non-emergency line. In case of emergency, call 911. 911 calls are recorded and may be accessed for later use. Communicate clearly and use plain language. Avoid using jargon, slang, or big words. Be prepared to provide clear, concise, and thorough information. What will a 911 call taker ask during an emergency? Where? Location of the emergency, address, intersection, or general directions. What? Type of emergency, fire, police, medical. When? Exact time frame. Try to avoid just occurred. Use specifics. Who? How many people were involved? Physical descriptions, location or direction of travel. Why? Circumstances surrounding incident. Example, why is person unconscious? Did they fall or were they punched? Weapons. Type. How many? Who has them? Answering the dispatcher's questions succinctly and accurately ensures the correct assistance is dispatched in a timely manner. When asked, provide your name and contact information. Additional information. Injuries. Violence. Type injuries still in progress. Alcohol, drugs. What type? Are they hazardous? Meth labs. Environmental dangers. Icy roads. Exposed electrical wiring. Leaking gas, etc. Safe route for hazardous material. Type of chemicals. Hazardous decals. Which way is the wind blowing? Is there a road to the scene that is not affected? Wires down. Location. In contact with a vehicle, person, or building? Is there a road to the scene that is not affected? Why stay on the line? A call taker may need the security professional to stay on the phone in order to provide additional information to emergency responders if it is safe to do so. Do not hang up until instructed to do so. If unsure whether it is appropriate to hang up, ask for clarification. Describing persons of interest. Describe from the top, head down, to the bottom, shoes. Gender, race, age. Height, weight. Make a mental note of where the top of the person's head is as it passes a fixed object like a door frame. This can give an accurate height estimate. Hair, facial hair, glasses. Scars, tattoos. Describing vehicles. License plate. State first, then letters from left to right. Direction of travel. Symbol is a useful acronym. It stands for symbol, color, year, make, model, body. Anything else? Primer damage? License plate, state. Other characteristics such as dents or bumper stickers. Page 56. Decision making and problem solving. Problem solving, the Sarah model. Scan, analyze, respond, and assess is a 4-step decision-making model. Scan, identify and define potential problems before moving to take action. A. Collect objective data to create a clear and shared picture of the potential problem. B. Determine what the problem really is and its extent. Is it a crime or an issue with a facility? What time did the incident occur and where? Who were the people involved? Analyze the underlying conditions by learning everything possible about those involved, incidents and history relating to the problem. What do I need to know about this problem? Who could provide an answer to the question? Are my actions going to contradict my employer's policy? Are my actions going to put myself or others' safety at risk? Who knows where I am? How long will it take for help to arrive? Respond. Based on analysis of the problem, a response may be to call for assistance, retreat, or interject. Responses take the form of short or long-term goals that answer the question, What am I trying to accomplish? Assess. To measure the impact of the response to the problem after the contact, think about what happened. For example, what was done right, what went wrong, and how to more effectively respond to similar situations in the future. Debrief. Responses can be considered successful if they accomplish one or more outcomes. Substantially reduce or totally eliminate the problem. Reduce the harm or fear associated with the problem. Improve the response to the problem. Manage resources better. Redefine problem responsibilities. Identify who is responsible. Self-analysis. What would you do differently next time? What did you do well? What could you do better next time? Page 58. Situational awareness. Situational awareness, defined: being aware of what is going on around you and being able to do something with the information. Includes the ability to determine quickly the context and relevance of events that are unfolding. Can be practiced by anyone with the will and the discipline to do so. Application of situational awareness. Constantly evaluate your surroundings. Recognize potential threats. Recognize dangerous situations. Identify criminal behavior. Pay attention to behavior cues and group dynamics. Read the situation and identify pre-assaultive clues. Verbal, obvious, defiant statements, subtle, tone, distracting, words not matching actions. Physical, obvious, red face, rolling up sleeves. Subtle, looking around, posturing. Monitor the hands. Punches, grabs, strikes, or uses weapons. Make inferences and investigate. Avoid task fixation. Focusing on a task to the exclusion of your surroundings. Trust your intuition. One's sixth sense can notice subtle signs of danger in ways the conscious mind has difficulty quantifying or articulating. Avoid boredom and apathy. Avoid tactically unsafe situations. Weigh your options and determine what the best course of action is. Develop safe routes. Train like your life depended on it. Responding to a stressful situation. When faced with a stressful situation, we generally default to gross motor skills, such as fight or flight. During this time, cognitive abilities can be reduced, resulting in fairly easy actions, suddenly becoming very difficult. This may be amplified if one has limited experience, i.e., making a citizen's arrest. Proper training allows one to default to their training to accomplish a task. Repetition in training develops muscle memory and appropriate reaction. Fundamentals. Patrol procedures. Learning outcome. Understand your scope of authority while effectively providing patrol services. 1. Be prepared. A. Ensure you have proper equipment. Uniform, tools, bicycle or vehicle. B. Become familiar with area. Area orientation, boundaries, directions, fastest routes in and out of an area or facility. C. Become familiar with environment, i.e., clients, citizens, potential crime targets. D. Become familiar with the client's purpose for patrols, i.e., unauthorized entry, crime prevention, etc. 2. Types of patrols. A. Foot, bicycle, or vehicle. B. Fixed, stationary, roving, moving, or baseline, Initial patrol to identify the conditions. C. Pros and cons. Vehicle patrols allow greater coverage, whereas foot or bicycle patrols allow greater citizen interaction. 3. Scope of authority and requirements. A. Obey all pedestrian and traffic laws. B. Observe, report, act. As a private citizen in this role, you have only the extended authority conveyed upon you by the property owner. C. Law. Limited authority of a private security professional. Page 21. C. Private security and public safety can be effective partners through establishing mutual trust, by speaking a common language in areas in which the duties of private security and public safety intersect, and by understanding one another's roles. Both can work together to ensure a successful resolution of a matter. Page 61. Post orders. Learning outcome. Understand the importance of following both company policy and site-specific post orders. Company policy describes generally how you are expected to conduct yourself or perform a task. Site-specific post orders are more in-depth or detailed descriptions of how to perform specific tasks. You must be familiar with company policy and site-specific post orders. If you operate within the scope of the employing company policy, both you and your company should be covered from liability. Alternatively, if your actions are outside the boundaries of the company policy, you could be liable for civil damages arising from your actions. Page 62. Identity checks. Learning outcome. Accurately conduct an identity check and detect false identification. Follow this process if the employer requires you to conduct ID checks. Compare the photo on the ID closely to the presenter. Compare the height and facial features on the ID. Weight and hair color may often change. If in doubt, ask the presenter questions about information on the card, such as to spell their address, their first, middle, or last name, etc. If you suspect someone of presenting a fake ID, the safest course of action is to return the ID to them and deny access to the venue area. Act in accordance with the client or employer's policies and procedures. If within venues licensed by the Oregon Liquor Control Commission, consult them prior to taking action. Detecting false IDs. The TLC approach should be used when checking for false and altered ID. T. Touch. The ID to feel for alterations. Feel for bumps, peeling lamination, cracks, slits, cuts, scratches, or uneven corners. L. Look at the ID. Search for misaligned numbers, letters, or photo. Look for darker or lighter print on some numbers or letters, erasures, uneven lamination, excessive glue, or fonts in a style and shape typically not used by state DMVs. C. Check. Check for authenticity. Look for state seals, colored photo backgrounds, official signatures, missing expiration dates, and information which would normally be apparent on an official ID. Scene management. Learning outcome. 1. Understand your role in scene management. 2. Understand how to effectively interact with public safety, reporting, managing, and relinquishing control to responders. Scene safety. 1. Identify problems. Example, a traffic collision. 2. Identify scope of problem. Example, trapped injured person and property damage. 3. Prioritize based first on risk to life, second on risk to property. Example, first concern is injured person, second concern is damaged property. Notify public safety. 1. Provide preliminary information. See communicating with 911, page 54. 2. Update 911 as necessary. 3. Provide officer safety information, such as a safe route and weapons. Scene approach. 1. Don't rush in. Use a controlled approach. Stop, look, and listen when possible. 2. Use ongoing assessment of problem. 3. Identify those involved: victims, witnesses, and suspects, and vehicles and weapons. 4. Identify the crime scene. Seek to contain it. Interaction with victims, witnesses, and suspects. 1. Provide victims with necessary medical assistance. Try to locate a relative or close friend to remain with the victim. 2. Ask witnesses to remain and not discuss the incident. You have no legal authority to detain witnesses or require them not to discuss the incident. 3. You may request their contact information for police if they wish to leave, but they are not required to provide it. 4. Unless you have personally witnessed a crime committed by an individual and you make a citizen's arrest, you may not detain a suspect. See Law, Arrest by Private Person, page 22. Protection of scene, evidence. 1. In general, double the distance of what you think the perimeter should be for a crime scene, if possible, and you are in control of the property, client's property. Cordon off the area. Request people refrain from entering scene. If not possible, note who enters and leaves. To the extent possible, protect any items you believe are evidence. This includes footprints, fingerprints, and tire tracks. Interacting and arriving with public safety. 1. Provide guidance for incoming responders. Location of incident, victim, suspect, and weapons. 2. Once emergency responders are on site, they are in charge. 3. Be cooperative and follow their direction. 4. Refusing to assist a peace officer is a violation. ORS 162.245. Medical emergencies. All medical injuries that are witnessed, reported, or suspected should be taken seriously. Always ensure the proper personnel have been notified. Medical emergencies can potentially result in large insurance claims and costly litigation. Always ensure an accurate and detailed report is written. When handling medical emergencies, keep in mind the following. Job duties. What are you supposed to be doing? Responsibilities. What are your responsibilities for? Expectations. What the client or company expects of you. Limitations of the client, company, and you. And scope. The aid rendered is within the scope of your training. Approaching the emergency scene. Follow the 5 steps when approaching a medical emergency. 1. Call 911. 2. Ensure the scene is safe. 3. Render medical assistance where appropriate. Secure the area scene, but only after immediate needs have been met. And gather critical information when the situation is stabilized, if appropriate. Gathering critical medical information. As long as there is no immediate life-threatening situation, you should attempt to obtain victim information, full name, first, middle, last, phone, address, brief medical history, medications, if appropriate. Contact person, witness information, full name, first, middle, last, phone, and address. When there's no one else specifically designated to deal with these emergencies, remember when in uniform, you are looked to for leadership, guidance, direction, and response. Page 66. The Good Samaritan Act. A Good Samaritan is the one who voluntarily renders emergency care or first aid at the scene of an accident or medical emergency. If the client does not require security professionals to render first aid, you are considered a member of the general public for the duration of the response. If you choose to respond and provide first aid, you must ensure you are operating within the scope of your training. When providing emergency care, attempt to gain consent prior to making physical contact. Liability for emergency medical assistance, ORS 30.800. Emergency medical assistance means 1A. Medical or dental care not provided in a place where emergency medical or dental care is regularly available. It is given voluntarily and without the expectation of compensation to an injured person who is in need of immediate medical or dental care and under emergency circumstances that suggest that the giving of assistance is the only alternative to death or serious physical after effects. Or B. Medical care provided voluntarily in good faith and without expectation of compensation. 2. No person may maintain action for damages for injury, death, or loss that results from acts of omissions of a person while rendering emergency medical assistance, unless it's alleged and proven that the person was grossly negligent in rendering the emergency medical assistance. The giving of emergency medical assistance by a person does not, of itself, establish the relationship between the person giving the assistance and the person receiving the assistance, insofar as the relationship carries with it no duty to provide or arrange for further medical care for the injured person after the giving of emergency medical assistance. Page 67. Disease awareness, prevention, and PPE. Learning outcome. Identify potential exposure to communicable and bloodborne diseases and demonstrate safe practices for prevention in a given situation. Awareness. Numerous communicable diseases and bloodborne pathogens cause serious concern for workers occupationally exposed to blood, spit, vomit, and other potentially infectious materials and certain other body fluids. Exposure to bloodborne pathogens occurs in many ways. Bloodborne pathogens can be transmitted through contact with eyes, nose, and mouth. They can be transmitted when the skin is punctured by needles or other sharp objects. Prevention and personal protective equipment. Best defense against contraction of diseases. Intact skin. Washing hands thoroughly with soap and water. 2. Disinfectants. A. Bleach. 1 in 10 bleached water dilution is effective for up to 24 hours. B. Medical grade disinfectant wipes or sprays. 3. Use of a biohazard container. All materials that have been contaminated with blood should be placed in the red biohazard container. Know where biohazard container is located. 4. Routinely disinfect all common areas. 5. Protective equipment. The responsibility for providing laundering, cleaning, repairing, replacing, and disposing of PPE at no cost to employees rests with the employer. Employers are not obligated under the standard to provide general work clothes to the employees, but they are responsible for providing PPE. B. Hypoallergenic gloves, glove liners, powderless gloves, or other similar alternatives must be provided for employees who are allergic to the gloves that are normally provided. Page 69. Fire. Fire detection, reporting, and safety. Learning outcome. Understand the primary public safety principle and your actions that can benefit emergency responders. Public safety principle. Call 911 before any action. Be familiar with the following to recognize potential fire hazards at the work site and effectively work with the fire department's response. Types of fire hazards they may encounter at each site, e.g. oil, paper, rubber, etc. The layout of each site or facility. Location of sensors, smoke alarms, alarm pull stations, and alarm panels in order to assist the fire department in locating the panel. Location of sprinkler system controls, fire extinguishers, and hose cabinets. Location of utility shutoffs, gas, water, electricity, and HVAC systems, and contact information for the site manager, maintenance personnel, or persons in possession of site keys. If at all possible, private security professionals should notify 911 prior to attempting to fight a fire. Subsequent actions. 1. Sound the alarm. 2. Attempt to notify occupants. 3. Evacuate. 4. Crowd control. 5. Provide assistance to responders. Unlock doors, provide keys or access cards. Fire extinguishers. There are many different types of fire extinguishers that correspond with the classification of fire they are designed to put out. The most common fire extinguisher is the ABC fire extinguisher, which is designed to put out Class A, Class B, and Class C fires. Fire departments typically use fire extinguishers that are designed to extinguish single classifications of fires. A useful tool when operating a fire extinguisher is the pass method. P. Pull the safety pin at the top of the fire extinguisher. A. Aim at the base of the fire. Aiming at the flames is unproductive. S. Squeeze the handle to start the flow of the extinguishing agent. S. Sweep at the base of the flame. Avoid a direct flow onto any one specific part of the fire. Call 911 before any action. Private security professionals are not qualified to determine whether a fire has been fully extinguished. The fire department will make the final determination that the fire has been extinguished. Material Safety Data Sheet 78. Call 911 before any action. When a spill, leak, or contamination has been determined, a Material Safety Data Sheet MSDS, Safety Data Sheet SDS, or Product Safety Data Sheet PSDS is an important component of occupational safety and health. It is intended to provide personnel and procedures for handling or working with hazardous substances in a safe manner and includes information such as physical data, melting point, boiling point, flash point, etc., toxicity, health effects, first aid reactivity, storage, disposal, protective equipment, and spill handling procedures. MSDS formats can vary depending on state requirements. SDS are a widely used system for cataloging information on chemicals, chemical compounds, and chemical mixtures. SDS information may include instructions for the safe use and potential hazards associated with a particular material or product. These data sheets should be found anywhere where the chemicals are being stored or used. An SDS for a substance is not primarily intended for use by the general consumer, focusing instead on the hazards of working with the material in an occupational setting. Page 71. Current trends. Active threat, active shooter. Learning outcome. Understand how to react in an active threat, active shooter situation. Coping with an active threat, active shooter situation. 1. Be aware of your environment and any possible dangers. 2. Take note of the 2 nearest exits in any facility you visit. 3. If you are in an office, stay there and secure the door. 4. Attempt to take down the active shooter as a last resort. Active threat. In most cases, a response to an active threat will involve a coordinated response from multiple law enforcement agencies. Remember, emergency preparedness is everyone's concern. Active threat is defined as an incident that by the deliberate nature creates an immediate threat or presents imminent danger to the community. Examples of an active threat: active shooter, hostage barricaded subject, sniper, suicide homicide bomber, known or suspected terrorist threat, biological chemical threat. In an event that an active threat becomes apparent in any location, the threat should be reported immediately as soon as it is safe to do so through 911. Page 72. Profile of an active shooter. An individual actively engaged in killing or attempting to kill people in a confined and populated area, typically through the use of firearms. Characteristics of an active shooter: generally has a specific target, but random victims are collateral damage. The event is unpredictable and evolves quickly. Law enforcement is usually required to end an active shooter situation. Although you will likely be in a uniform and citizens will look to you in a leadership role, as an unarmed private security professional, you do not have the tools, equipment, or the training to engage or stop the shooters. How to respond when an active shooter is in your vicinity. Follow specific employer policies and procedures. A company policy will address specific issues for the clients that the company serves and the environment in which the service is provided. In the absence of a specific employer policy, an example of options to consider is run, hide, fight. Run. Follow specific employer policies and procedures. Have an escape route and plan in mind. Leave your belongings behind. Keep your hands visible. Hide. Hide in the area out of the shooter's view. Block entry to your hiding place and lock the doors. Silence your cell phone. Fight. As a last resort, and only when your life is in imminent danger, attempt to incapacitate the shooter. Act with physical aggression and throw items at the active shooter. Call 911 when it is safe to do so. How to respond when law enforcement arrives. 1. Remain calm and follow instructions. 2. Put down any items in your hands, i.e. bags, jackets, cell phones. 3. Raise hands and spread fingers. 4. Keep hands visible at all times. 5. Avoid quick movements towards officers, such as holding on to them for safety. 6. Avoid pointing, screaming, or yelling. 7. Do not stop to ask officers for help or directions when evacuating. Information you should provide to law enforcement or 911 call taker. 1. Location of the active shooter. 2. Number of shooters. 3. Physical description of shooters. 4. Number and type of weapons held by shooter. 5. Number of potential victims at the location. Bomb threats. Learning outcome. Articulate the questions to ask and observations made in the event of a bomb threat. The call. Questions to ask. 1. When is bomb going to explode? 2. Where is it right now? 3. What does it look like? 4. What kind of bomb is it? 5. What will cause it to explode? 6. Did you place the bomb? 7. Why? 8. What is your address? 9. What is your name? Exact wording of the threat, write it down verbatim. Information for law enforcement about the caller. Male or female? Age? Race? Length of call? Number at which call was received from caller ID. Background sounds, street noises, voices, PA system, house noises, office noises, booth noises, factory noises, animal noises, clear, static, local, long distance, other. The threat language. Are they well spoken? Educated sounding? Or foul and crude? Irrational? Incoherent? Taped? Message read by threat maker? Caller's voice. Calm? Angry? Excited? Slow? Rapid? Soft? Loud? Laughter? Crying? Normal? Distinct? Slurred? Nasal? Stutter? Lisp? Raspy? Deep? Ragged? Clearing throat? Deep breathing? Cracking voice? Disguised? Accent? Familiar? Private security should become familiar with the specific policies and procedures prior to an event, so they are prepared when or if the decision is made to evacuate the building due to a known threat. Example of an evacuation procedure. 1. Primary and secondary evacuation routes should be searched and cleared prior to the evacuation signal. 2. Occupants should leave the office spaces open, unlock desks, cabinets, and lockers, turn off machinery, and remove their briefcases, purses, etc. 3. Occupants should conduct a cursory search of their immediate work areas. 4. Establish evacuation holding areas at a suitable distance with cover, already cleared away from vehicles. 5. Establish communications for search, security, and re-entry into the building. 6. Do not operate electrical equipment. Perimeter. Minimum safe distance is 300 feet in the open. If the device is large, then you need more distance. The type, size, and shape may determine more distance is needed. 2. Rule of thumb. If you can see the device, it can hurt you. 3. Pipe bomb end caps are deadly missiles. 4. Think of glass as a secondary fragmentation. 5. Use hard cover. 6. Further is better. 7. Once police arrive, they will expand or decrease. Do not operate radios or cell phones within a minimum 100 feet of a suspected device. Treat all suspect devices as real until proven otherwise. Page 76. Weapons of Mass Destruction Awareness. Learning outcome. Understand the concept of deterrence through threat indicators and understand how to respond to a weapons of mass destruction (WMD) incident. Prevention and deterrence. This information establishes a common baseline to ensure nationwide consistency in WMD education and training. This training provides individuals with definitions. Terrorist threats indicators include suspicious persons and vehicles, along with potential terrorist targets, and the concept of RAIN: recognize, avoid, isolate, and notify. Terrorism is activities that involve an act dangerous to human life or potential destruction of critical infrastructure or any key resource, and that is a violation of the criminal laws of the United States or any state or other subdivision of the United States in which it occurs. It is ended to intimidate or coerce the civilian population, or influence a government, or affect a government by mass destruction, assassination, or kidnapping. Weapons of mass destruction, WMD defined. Any explosive, incendiary, or poison gas, bomb, grenade, rocket having a propellant charge of more than 4 ounces, or missiles having an explosive or incendiary charge of more than 1/4 ounce, or mine or similar device. Any weapons that is designed to intend to cause death or serious physical injury through the release, dissemination, or impact of toxic or poisonous chemical or their precursors. Any weapon involved in a disease organism. Any weapon involving a disease organism. Any weapon that is designed to release radiation or radioactivity at a level dangerous to human life. Page 77. Threat factors. Terrorists may have military-style training and goals of creating mass casualties, not only by using a WMD, but also by manipulating others. Factors to make an attack more lethal are surprise. Relative to the time of attack, the element of surprise in a terrorist attack allows more reward to the terrorist. Means of attack, limited only by the terrorist's imagination. The attack can range from releasing a chemical WMD, biological WMD, radiological WMD, or an improvised explosive device. Target of the attack. Targets can be individuals targeted for assassination, critical infrastructures, and targets of symbolic value. The goal is mass casualties. Foreknowledge of the community response. Terrorists will almost always conduct extensive surveillance, especially of exercises involving WMD. Terrorists will understand a community's capability to respond to any mass casualty incident through their surveillance of the community's responder resources, and they will plan accordingly. Significant dates. Attacks have been related to significant dates such as September 11, 2001, 9/11. Threat indicators. Threat indicators are observed behaviors, activities, and or items construed as terrorist planning efforts or impending attack. Gathering of target intelligence. Acquisition of materials necessary for an attack. Many items used to construct and transport weapons of mass destruction are available in all communities. Preparation of weapons. Strong chemical smells coming from apartments or residences, or large drums of materials being moved. First step of executing an attack: bomb delivery, gaining access to a plane, etc. Be aware of unusual activities around potential targets. For instance, individuals attempting to gain access to a restricted area, or vans or trucks left unattended in close proximity to a potential target. Page 78. Suspicious persons. In vehicles or using other means of conveyances, arriving and departing locations at odd times of the day or night. Suspiciously exiting a secured, non-public area near a train or bus depot, airport, tunnel, bridge, government building, or tourist attraction. Who stays at bus, train stops for extended periods while buses, trains come and go. Who doesn't fit into the surrounding environment because they are wearing improper attire for the location or season. Who exhibits suspicious behavior such as staring or quickly looking away from individuals or vehicles as they enter or leave facilities or parking areas. Suspicious vehicles. Vehicles left unattended or abandoned, or that appear to be out of place. Any vehicle suspected of doing mobile surveillance, such as automobiles carrying camera equipment or vans with tinted windows near potential targets. Vehicles with removable decals or signage that has been painted over or altered. Altered frames, such as cutouts in the body of the vehicle. Suspicious actions, objects. Suspicious packages, luggage, or mail abandoned in a crowded place, such as an office building, airport, school, or shopping center. Chemical fires, toxic odors, or brightly colored stain in apartments, motel rooms, or self-storage units. Unusual test explosions in rural or wooded areas. Purchase of or illicit access to facility blueprints. Parcels, packages, or luggage left unattended. Maybe heavy mail packages with excessive postage. Unusual behavior such as staring or quickly looking away from personnel or vehicles entering or leaving designated facilities or parking areas. Increase in anonymous telephone or email threats to facilities in conjunction with the suspected surveillance incidences. Questioning of security or facility personnel. Any unusual activity or circumstance in your neighborhood, community, or workplace. Page 79. Potential targets. Critical infrastructure, telecommunications systems, electrical power grids, transportation systems, gas, oil delivery and storage systems, water purification and delivery mechanisms, banking and finance centers, police, fire, EMS, disaster systems, and other government services. Other potential targets. Gathering present terrorists with targets and the potential for causing many casualties. Schools, sports arenas, malls, concert halls, high-rise residences, office buildings, places of worship. Terrorist tactics. Terrorists possess a wide range of tactics and an even greater range of targets. Terrorists will use the tactic that guarantees them the greatest impact with the least amount of risk to their operation. The goal is to inflict mass casualties or disrupt critical infrastructure. Secondary devices, which are generally intended to injure or kill responders. There may be multiple incidents. There may be rapid escalation of the hazards. Immediate actions. Individuals trained to the awareness level are not qualified or certified to perform ongoing operations or support at the scene of a WMD incident. This awareness training is designed to prepare individuals who, in the course of their everyday duties, are likely to witness or discover a hazardous substance release. Page 80. RAIN. R-A-I-N. Recognition, avoidance, isolation, and notification. RAIN is used by individuals to gather quickly and process information and to synthesize the information in order to facilitate life safety actions in a WMD incident. R. Recognize the hazard, threat. What do I see, hear, or smell? Rapid interpretation and mental processing of an event. A. Avoid the hazard, contamination, and injury. What do I stay away from? Actions to avoid liquids, powders, clouds, or vapors, and out of sight of any potential improvised explosive device, IED. If you can see the bomb can kill you. Get out and stay out until all clear signal is given. I. Isolate the hazard area. Whom do I protect? Action to isolate or reduce exposure to contamination or threat. Attempt to remove myself from the contaminated zone. Remove other people who may be in the contaminated zone, and to keep people from going into the contaminated zone. N. Notify the appropriate support. Whom do I call? Action to notify your command authority, giving them as much information as possible about the incident. Page 81. Report writing. Apply basic writing skills necessary to accurately document incidents and events. Who reads your reports? Supervisors, clients, co-workers, police, courts, media, and others. Types of reports: incident, use of force, investigative, logbook. Well written down reports: document actions, communicates information, creates a record for future testimony. Cases are dismissed because of factors including poor reports. Incorrect facts: names, statements, times, dates. Writer not knowledgeable of law, rules, or policies. Writer unable to accurately communicate facts to the reader. Quick reference. Print and save. Example of a report writing process. GROW. Follow specific employer's policies and procedures. GROW. G. Gather the facts. R. Record the facts. O. Organize the facts. W. Write the report. E. Evaluate the report. Step 1. Gather the facts. Assemble the information. Investigate and interview. Examine all relevant information. Step 2. Record the facts. Collect data immediately. Record information. Update notes as necessary. Remain objecting and professional. Ensure it is complete and accurate. A. People. Full name, legal name, aliases or nicknames, gender, date of birth, race, ethnicity, nationality, origin, physical descriptions, scars, marks, tattoos, clothing, if needed for identification, identification numbers, driver's license, address, home and work, phone, home, work, cell, occupation, even if unemployed, employment, hours, shift worked. B. Vehicles, motorbikes, license plate number, state of issue, and vehicle identification number, color, make, model, year, etc. Customization damage to contents. C. Bicycles, make, model, name, and serial number, size and color of frame, equipment, e.g. light, kickstand, etc. Customization equipment, owner's name and address. D. Weapons, type, handgun, shotgun, knife, manufacturer, model, caliber, finish, distinctive features, conditions, modifications, accessories, original, handmade, stolen, purchased. Step 3. Organize the facts. Arrange in a logical manner, generally chronological. Use an outline identifying primary and secondary points. Page 83. Quick reference. Step 4. Write the report. Always use first person. Write as though you were speaking with the reader. Good writing is simple writing, in the simplest and most direct manner possible. Avoid long sentences. Avoid uncommon abbreviations. Avoid police jargon. Proceed versus drove. Advised versus told. Keep pronoun references clear. Repeat names instead. He told her that she was dead versus Smith told Jones that Walker was dead. Opinions must be identified as such and the basis for them established. Conclusions must be supported by fact. Remain objective. Be unbiased. Narrative content. Who, what, where, when, why, and how. Who are involved or referenced. What, describe what occurred. Where, location of incident, actions, and evidence. When the incident occurred, use chronology and identify when actions occurred, statements were made, and evidence located. Why this may establish the culpable mental state of knowing or with intent. Actual statements quoted in a report can establish the element. How requires fact and objective conclusion. Step 5. Evaluate the report. Edit, proofread, revise. Read aloud to hear how it sounds, flows. Answer the following questions. Is the report based in fact? Is the reasoning sound? Does the report contain sufficient information? Do the facts need interpretation? Has too much material been included? Are spelling, capitalization, and punctuation correct? In the writing, legible and easily read. Is the writing legible and easily read? Spelling. Ensure names are correctly spelled. Check words that sound alike but are spelled differently, i.e., there, there, there. Punctuation. Commas. Too few versus too many. Too few is a run-on sentence. Too many means it should be more than one sentence. Used to separate a series of words or phrases. For a series of descriptive words. For a list. To surround words or phrases not essential to the meaning of the sentence. Periods. At end of sentence. To show numerical division, example decimals, money, etc. After the most abbreviations, example, etc. MS, miss. A series of 3 periods, an ellipsis, is used to show omission of words. Question marks, used to end a questioning statement, should not be used at the end of an indirect question. Grammar, used first person, I. Present, past, and future tenses. Write in past tense unless you are quoting someone. Do not shift tense. Write in an active voice, not a passive voice. I found a knife versus a knife was found.